Hi everyone, we are going to get started in just a few minutes here. We're going to allow maybe a minute or so for people to sign on to the broadcasting. We'll get started in just a minute. For those of us just joining us, we're going to start in just about 1 minute. We're just going to allow people a moment to sign on here. All right, well, I think we're going to get started. My name's Connor Hannigan. I'm a staff attorney at the Cancer Legal Resource Center. I just want to thank you for taking time out of your day to join us here. I'm also a primary caregiver for someone who is living with cancer, so hopefully we can discuss some valuable information for everyone attending today. There are over 40 million Americans that serve as family caregivers, and most of us are unaware of the services and resources that are available to support us. So today we're going to talk about the legal rights of caregivers to take time off work, some ways to avoid discrimination, and we're going to learn also about some other caregiver resources that are available. First off, I just wanted to let everyone know what the Cancer Legal Resource Center, or the CLRC, is. We're a program of the Disability Rights Legal Center, and our mission is to serve people who are affected by cancer, including patients and caregivers, and assist them with navigating complex legal issues. We generally don't provide direct representation on this project or give specific legal advice. We focus more on the educational model in order to empower individuals with knowledge of their rights under the law and give referrals to other legal resources when necessary. We have people on staff who speak English, Spanish, and French, and of course we keep all information confidential. The CLRC operates a national telephone assistance line. We gather detailed information about someone's legal issue that they present with, and then provide them with customized resources and information pertinent to their issue. People can call to ask cancer-related legal questions for themselves or on behalf of someone else. And it actually is always best to complete our online intake form. It's normally much faster, and that eliminates any potential phone tag that can come with trying to get in touch with our voice messaging system. Also, just so everyone knows, we're going to be putting this webinar and all of our other recent webinars up on our website. We have a YouTube channel as well, so if you want to revisit any of this information that we cover, please feel free to do so. We have a lot of information up on our website, www.cancerlegalresources.org. So feel free to look at that, some step-by-step tips to different things that might come up. And what are some of those things that might come up, and what are cancer-related legal issues that someone might contact us about? Here's a list of most of the most common ones that people living with cancer frequently face, and we'll touch on a few of these in the presentation today. The CLRC exists to help people navigate some of the laws related to these issues, and we have resources and referrals related to all of them. So one of those resources is the Patient Legal Handbook, which we've recently released a second edition of. The handbook can be downloaded on our website for free, or if you're a social worker or healthcare provider and you need to order larger quantities for distribution, you can do that through our website as well. The handbook's designed to discuss how to avoid some of the major legal pitfalls that occur following a cancer diagnosis and help to make people aware of what their rights are in various situations. So we also have numerous tips included in the handbook, and we are going to discuss a few of those today. So I just wanted to do a quick overview of some of the topics we'll be discussing today. And please remember that if you have any questions or on anything that we discuss, you can feel free to type a question into our chat box. I'm going to try to leave time at the end of the presentation to discuss those questions. If you have a question that's specific to your situation, you can feel free to complete an intake online, and we'll get back to you with a personalized response. And if you have a more general question related to anything that we discuss, please feel free to type away in the chat box. One distinction that I'd like to get to right off the bat is that for today's discussion, we're going to be mostly talking about how federal laws can protect people living with cancer as patients or survivors and caregivers. So keep in mind that all of these laws are just a baseline. And as we'll discuss, state laws vary from state to state. So you might be entitled to more protections in various contexts, including through these state and local laws, or potentially through employee manuals or contracts and insurance plans. So be aware of that. So for the first thing that I want to discuss is talking about whether there's a duty as a caregiver. And there is generally no legal requirement to become a caregiver, regardless of whether the person who is ill is a family member or a close friend. A person can take on responsibility for a patient's health, which can then create a duty of care, though. So whether a caregiver has taken on a duty to care for another person and the extent of that duty, that's going to depend on each situation. One exception to this is a parent's duty to take care of their minor children. However, once a child reaches the age of majority, the parental obligations cease. Adult children don't have a legal duty to care for their patients, despite some cultural traditions that do have that. So you don't generally have to be someone's caregiver, but once you begin to act like their caregiver, you do have a duty to do so responsibly. And next, we're going to discuss some protections in the workplace. It's important to check individual and state laws and services which may provide additional coverage or benefits. The Americans with Disabilities Act is a federal anti-discrimination law that protects people with disabilities, and in some instances, caregivers. Many people with cancer don't consider themselves disabled. It's important to note that the definition of disability is different in various legal contexts. So often, regardless of how a person chooses to affiliate themselves, it's important to start with the definition of disability to see if a disability law offers protections or benefits to a person living with cancer, and then look to see if any protections apply to caregivers. As we all know, a person's abilities are constantly changing with a cancer diagnosis, so therefore it may be necessary to reassess eligibility for programs and laws if a patient or survivor's abilities change. As we talk about these laws in the context of caregiving, it's also important to think about how these laws can serve the people we're caregiving for. So as you may have experienced when a person's sick, it's extremely helpful to have someone advocate on their behalf. There are three parts to the ADA's definition of disability. First is that the person has an impairment. Second is that the impairment limits a major life activity. And third, that the limitation is substantial. So major life activities are broad for the purpose of the Americans with Disabilities Act. They include walking, talking, breathing, eating, caring for yourself, and the particularly broad activities of daily living. If important parts of a person's life are affected by their cancer diagnosis, then they may be eligible for the ADA's protections against discrimination for both their caregiver and themselves. In terms of the substantial limitation requirement, a substantial limitation is an inability to perform a major life activity in a way that a person in society would normally be able to perform it. Cancer can be a disability under the ADA, but it's determined on a case-by-case basis. So it's not just the cancer illness itself that's considered, but also the side effects of the treatment, which we all know can be much worse than the actual diagnosis. So remember that some state anti-discrimination laws may specifically list cancer as a disability, such as in California, or they may have a lower standard than a substantial limitation. So the Americans with Disabilities Act prohibits private employers with 15 or more employees from excluding or denying equal jobs or benefits because of an individual's relationship or association with an individual who has a disability. And so that can include cancer or the effects of cancer. Remember that many states have their own anti-discrimination laws that lower the number of employees required to as little as 1 or 2 employees in a company. This is just the federal baseline. So how does this impact us as caregivers? The Americans with Disabilities Act prohibits qualified employers from excluding or denying equal jobs or benefits because of an individual's relationship or association with an individual who has a disability. So caregivers should therefore not be treated differently or have their employment terminated by an employer based on knowledge that the caregiver has an association with a person with a disability. An example of this could be an employer who assumes that a caregiver won't be able to handle their normal workload or a big client, or if a caregiver gets passed over for a promotion at work because the employer knows that they're caring for a person who's sick. Familial caregiver discrimination is also prohibited under the Genetic Information Non-Discrimination Act, or GINA, since employers can't discriminate based on family medical history. So although caregivers are protected against job discrimination due to their associations with a person with cancer, they're not entitled to reasonable accommodations such as a reduction of work hours or a modification of the workplace, unlike a person with a disability who might be eligible for accommodations. If an employee's work performance drops due to caregiving responsibilities, employers can make employment decisions based on performance to terminate employment. But if an employee is performing their job adequately and an employer learns about their caregiving responsibilities and treats them differently, then they may be discriminating under the ADA. So now we're going to discuss another federal law commonly known as FMLA. That stands for the Family and Medical Leave Act, which allows qualified employees to take up to 12 weeks of unpaid leave at once or in shorter blocks of days or even a few hours within a 12-month period. This law applies to patients and caregivers of a spouse, child, or parent with a serious health condition. Medical certification from a healthcare professional is often required, stating that a caregiver's services are needed. A person is allowed to take FMLA time off to care for themselves or a covered family member. And so people that qualify as a covered family member so that a caregiver can take time off from work under FMLA are parents or a person acting as a parent, minor children, including biological, adopted, and foster children, or adult children who are incapable of self-care because of a mental or physical disability, and spouses. The law unfortunately does not allow caregivers to take time off to care for their siblings. Not all employers are covered by this federal law. Government in terms of local, state, and federal employers are subject to FMLA, and private employers only if they have 50 or more employees within a 75-mile radius. So if they have multiple offices within a 75-mile radius and those employees total more than 50, then they would qualify. So remember that some similar state laws may exist that could provide additional protections. Employees at those companies must have worked at least 1,250 hours in the past 12 months and must have worked for their employer for at least a total of 12 months in the last 7 years. The 12-month requirement doesn't need to have been all at one time if someone's a seasonal worker, for example, and the 1,250 hours averages to someone who works about 24 hours a week. If someone's going to take FMLA leave, it's important to talk to your employer about going on leave. The employee will likely have to provide medical certification. In a caregiving situation, they'll need to provide medical certification about the person who needs caregiving, and it may be necessary to include information that's different from what the patient would have to share if they were the employee. The Department of Labor has a separate form for family members. Employers must comply with all applicable laws regarding confidentiality of medical information, and therefore the employer must keep the employee's medical information and/or records separate from their personnel files in order to protect their privacy. An important tip is if you ask a general practitioner to complete the medical certification, their letterhead will not necessarily say oncology on it, and you can then avoid disclosing the nature of the illness to an employer if you don't wish to let them know. If you had your oncologist do it and they had on there that they practiced oncology, the employer would be able to identify what the illness was of the person that you're caregiving for. The CLRC has also created a helpful handout on our website about the types of information that has to be included in a medical certification, and also importantly, what types of information that does not have to be included. So like I mentioned earlier, you can take up to 12 weeks of leave at a time, and that doesn't have to be taken all at once. During FMLA, the employer can require or the employee can elect to take any paid vacation or sick time as well. The next definition I'd like to get into is that 12-week period of the job and health benefit protected leave under the FMLA. Those 12 weeks of leave can be taken all at once in a 12-week block of time or in intervals such as 1 week per month for chemotherapy or every third Friday off for a doctor's appointment. So you can use that intermittent leave only when it is medically necessary. If the employer requests it, the employee has to provide a certification by a healthcare provider, which states that working on this different schedule or being able to take leave on an intermittent basis is necessary to provide treatment to either the employee or provide care to or provide psychological comfort to a family member with a serious health condition. Employers have to calculate FMLA leave using an increment of time that's no greater than the shortest period of time that the employer would use to account for use of other forms of leave. So for example, if the employer calculates leave in blocks of 3-hour shifts, you have to take a 3-hour vacation block or something like that, then missing most of one shift will count as missing 3 full hours, but may not count as missing a full day off of work. It's important to know that FMLA can work alongside the Americans with Disabilities Act for patients. For example, if a patient took 12 weeks of FMLA leave but were not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA, especially if a definite end to the leave is apparent, which might make it more reasonable. However, taking more time off of work is not always reasonable and is decided on a case-by-case basis. Unfortunately, because caregivers are not eligible for reasonable accommodations under the ADA, a caregiver would have to their employer's policies or a handbook for additional protections, sometimes given to employees or potentially state laws. Paid family leave is available in certain states, so it's important to check with your local government agency to see whether it's an option in your state. The states that do have the program provide partial wage replacement during leave for a period of time that is limited. Paid family leave programs are usually run through the state's short-term disability insurance program, and that's funded through the employees themselves. These state laws often work in conjunction with FMLA, so someone in Rhode Island may take 4 weeks of paid family leave before taking 12 weeks of FMLA leave. It's important to see your state law for details. It's also important to note that being entitled to paid family leave doesn't necessarily mean you're entitled to FMLA leave, and some paid family leave programs allow income replacement to take care of family members that are other than just a parent, spouse, or child. Starting in 2019 in New York, the number of weeks eligible employees can take to care for a sick family member is going to increase to 10 weeks. The number of weeks employees can take will continue to rise in New York through 2021, at which time employees will be able to take up to 12 weeks. In New York for 2019, employees taking paid family leave receive 55% of their average weekly wage, and that's up to a cap of $1,357.11. So if a worker received $600 per week while working and had to take paid family leave, their weekly benefit would drop to 55% of that, being $330 per week. Employees there have job protection during this time. They can keep their health insurance and are protected from discrimination and retaliation. So the next tip that I want to discuss is about having difficult conversations early. And doing that is important so that the patient can create valid legal documents while they have the ability to understand and make informed decisions. So unfortunately, the longer that someone waits while an illness progresses, the greater the likelihood that these documents may be called into question. People must have the mental capacity to create these documents for them to be valid. It's also essential that you allow a patient to make their own decisions. So while it's important to discuss these with the patient ahead of time, if a caregiver is pressuring a patient to make healthcare and financial decisions, documents can also be called into question for fear of undue influence, pressuring the person to make a decision that they did not actually wish to make. Check to make sure that existing documents are up to date if you already have them, that they follow current state laws, that all assets are covered, and the current beneficiaries are named. It can be helpful to talk to an attorney to avoid common mistakes, which could result in making documents invalid, and avoid questions of undue influence. As a caregiver, I found that it may provide insight to you to also create these documents yourself. Advanced healthcare directives are written instructions that state a person's wishes about the medical care and treatment that they wish to receive if they're unable to make medical decisions for themselves. These may include types of treatment that should or should not be used. Advanced healthcare directives are intended to avoid unwanted care, reduce suffering, and ensure that a person's wishes are honored at the end of their life. A hospital visitation directive states that people who may or may not visit in the hospital according to the patient's wishes, and that may sometimes be included with the durable power of attorney for healthcare or a separate document. We had a friend who was unable to communicate her wishes and was faced with the choice of being in pain but more cognizant, or in less pain but less cognizant. And her family members thought that she'd want to be more aware so she could communicate with them, and then some arguments started to break out between family members because it was a difficult time. Fortunately, this friend had completed an advanced healthcare directive stating that her priority was not to be in pain. And so the medical team checked the advanced healthcare directive, then they made sure she was comfortable, and it ended any sort of family drama, and it wasn't an issue for them. If advanced directives seem overwhelming to you, you may wish to look at something called the 5 wishes. As a caregiver, I think the 5 wishes are helpful to fill out on your own, along with providing them to the person that you're caring for. This will give you an idea about what questions are helpful to ask, and then some insight into what questions are harder than others to answer. While it's always best to ensure that you have an attorney look over any legal documents, that's not possible for everyone due to costs and constraints. The 5 wishes meets the legal requirements for an advanced directive in 42 states and the District of Columbia. In the other 8 states, your completed 5 wishes can be attached to your state's required form. It does cost $5 to request the actual 5 wishes form, but it asks some great questions and gives good suggestions about what someone might want their advanced care to look like. Caregivinginfo.org is another great option because they have advanced directive forms with extensive instructions that make filling them out as clear as possible. Many hospitals also have their own advanced directive forms and free notary services. Power of attorney for healthcare, then that might the name of that might change depending on what your state calls it. Names someone who's either a relative, a friend, or someone else whom you trust to make medical decisions for you when you're not able to. A power of attorney deals with all medical decisions unless you decide to limit it. A patient can also give specific instructions about treatments that they want or don't want, or about other issues that concern them. So it's important to consider who's named as the power of attorney for healthcare. Ideally, they should be someone who's trustworthy, that shares the same values as the patient, and someone that has been talked to about what the patient's end-of-life wishes are. Sometimes a close family member is the best option. Sometimes that's too difficult to be so close to someone, so people select others that may have an easier time making those hard decisions. Power of attorney for financial affairs allows a patient to name another person to handle financial matters for themselves, including paying bills, signing and depositing checks, and accessing bank accounts. Power of attorney for financial affairs is a legally binding document that a person prepares or has prepared for them to sign, where they choose a trusted person, then known as their agent, to act for them if they become incapacitated or unable to act or speak on their own behalf. Whether or not someone is incapacitated is then determined by a doctor or a judge. For any power of attorney to be valid, it has to be signed and might have to be notarized depending on what your state's requirements are. It'll end as soon as someone passes away, so that agent won't have authority over financial affairs later on. If you have a will after that person passes away, then the will take effect. Might also be helpful to check with your bank about whether they have their own forms that they want filled out. Even though banks have to honor the power of attorney, it can make it easier for everyone involved if the bank's own forms are filled out. The two most common types of power of attorney for financial affairs are durable and springing. If a person wants an agent to start making decisions for them today and for that agent to continue making decisions for them when they become incapacitated, that would create a durable power of attorney. A durable power of attorney starts now and stays in effect. If someone wants an agent to act only when they're unable to make their own decisions, when they're found incapacitated, then they'd create a springing power of attorney. Whether or not someone's incapacitated, again, is determined by a doctor or judge, and that person that they choose to be their agent doesn't get to start making decisions for them until they're determined to be incapacitated. So the most common type of this is a combination of these two, known as a durable springing power of attorney. The privacy rule, which is a federal law under the Health Insurance Portability and Accountability Act, or HIPAA, gives individuals rights over protected health information and sets rules and limits on who can look at and receive health information. Therefore, written permission is needed for a caregiver who's not a parent or guardian to access medical records. However, if a caregiver is the patient's healthcare agent or power of attorney, then they will have access to the medical records. Doctors also have discretion to share medical information with caregivers or family members if they think that information is integral to the patient's care. Next, we're going to talk a little about medical debt liability and some benefits programs. When someone passes away, their estate is responsible for paying off their debts. So if the estate goes through probate to establish the legal validity of a will, a designated administrator or executor will look at assets and debts, guided by law to determine in what order bills should be paid. There are a few situations in which someone else might be responsible for medical debt should a person pass away. If someone shares a joint account with a family member or business partner, then creditors may be able to access that account to cover the balance on a debt. Most, but not all states apply the doctrine of necessaries, wherein a husband or wife could be held responsible for the purchase of essential goods and services, including food, clothing, shelter, and medical and legal expenses. A spouse could be liable for their other spouse's debts and contracts regardless of their consent or knowledge of a purchase. Creditors could therefore sue either spouse to recover debts on necessary goods and services, but generally debts incurred before marriage by a spouse don't become the responsibility of the other spouse. Adult children and other non-spouse caregivers are not responsible for the medical debts of their parents or patients unless they've specifically signed something agreeing to pay or be held liable if the patient was unable to pay. Some states have laws that make spouses liable for marital debts. Many states are community property states where certain assets and debts are shared equally in marriage. So other states have similar laws that require the sharing of debts. It's important to speak with an attorney in your state to understand these requirements. Social Security survivor benefits are payments made by Social Security to family members of people eligible for Social Security benefits but who've passed away. Also, if a patient becomes incapacitated but still alive, a caregiver may also potentially become the representative payee if that patient is still receiving Social Security benefits. And the same is true for veterans benefits, called a VA fiduciary, to help them pay the things that they need to cover. To be eligible for Social Security retirement benefits, a person must have worked and paid into Social Security. Certain family members may be eligible to receive monthly benefits, and that could include a widow or widower, age 60 or older, or age 50 or older if disabled. A surviving divorced spouse under certain circumstances, a widow or widower at any age who's caring for the deceased child or who's under age 16 or disabled. Many jobs, such as teachers, have a separate retirement and disability fund that may take the place of Social Security. If someone passes away, it's important to contact Social Security or a legal aid that lists Social Security or government benefits as a practice area as soon as you can to make sure that the family of the deceased gets any benefits that they're entitled to. Some things to keep in mind are that there are limits on how much survivors may earn while they receive benefits, and benefits for a widow or widower may be affected if they remarried before age 60 or age 50 if they are disabled or they are personally eligible for retirement benefits. So being a caregiver, as we know, is a daunting task. Even if you're not the sole or primary caregiver, we all know that caregiving can take its toll. There are some resources that exist to make the tasks involved in caregiving more manageable. There are nonprofits that exist that help caregivers communicate with friends and family to get help taking a patient to medical appointments or coordinate food drop-offs. There are websites that allow people to do fundraising campaigns for important medical, rent, and other costs, such as GoFundMe. Additionally, it may be helpful to seek out support groups, counseling services, and message boards to connect with others and learn about things that have worked for other caregivers. I've also found that it's important to remember that being a caregiver means also remembering to care for yourself. Self-care involves things such as making sure you go to regular doctor's appointments yourself, eating healthy, exercising, taking breaks that allow you to do things that you enjoy. And these needs aren't selfish. They help you become a better caregiver for the people that you care about. So next, I want to talk a little bit about accessing professional caregiving assistance. Many state or local health departments have licensed home care agencies. Services can include visits by nurses or social workers, medicine delivery, and help with daily tasks. Clients can pay privately or through private insurance coverage. And these agencies may also contract to provide services to patients on Medicare and Medicaid. Private long-term care insurance may also cover some home care. You can ask the insurance agent or the caseworker, which is always good to check and see if they have one, to explain benefits and conditions or read over the patient's policy to understand whether they have coverage. Some states have consumer or patient-directed programs which would pay a family member or friend in certain circumstances. There are strict rules for these, and there are waiting lists that generally apply, but you can contact your Medicaid office or the National Resource Center for participant-directed services, and that information is on the slide here. Another option is hiring a private professional or a friend. Formal care contracts may set up a payment arrangement between a patient and a caregiver. It's important to consult a lawyer if possible to make sure that the contract meets any tax requirements and, if necessary, Medicaid requirements, and that it's approved by all of the parties involved. Check to see if household insurance, such as your renter's or homeowner's insurance, covers household employees in case of an accident. If you're hiring a friend, don't forget to consider that there are potentially serious emotional pitfalls that can occur when you're transitioning a friendship into an employment relationship. Palliative care is medical care focused on improving the quality of life for people with serious illnesses. So it's not just for end-of-life care. Palliative care plays an important role throughout a serious or chronic illness. These don't necessarily have to be for terminal illnesses. And the goal here is for the care team is to focus on the quality of life of the patient and help people live well and achieve quality of life as they defined it. What that means is that the team might try to make a person comfortable by treating or easing their symptoms from an illness, not necessarily or not specifically curing the underlying disease, which can be conducted by the oncology team at the same time. This type of care includes pain and symptom management, communication and coordination of services, emotional and spiritual support, diet and nutritional information, and family and caregiver support. And sometimes doctors will tell patients that maybe they aren't ready for palliative or palliative care, but a patient does not have to be dying to be eligible for the care to be appropriate. So it's still important to ask for the referral if there are symptoms the patient would like to have managed better. If a doctor or hospital or insurance network does not have palliative care doctors to refer you to, you may want to consider seeking additional treatment elsewhere or asking for an out-of-network referral. So most insurance plans, including Medicare and Medicaid, can cover all or part of this care treatment, just as they would cover other hospital and medical expenses. So for example, if a patient's depressed and needs to see a mental health professional and be prescribed antidepressants, that would generally be covered under any health insurance plan. And the same is with pain medicine, consultations with a nutritionist or other things like this. So although palliative care is not the same as hospice, it is an integral part of hospice services. Hospice care requires a terminal diagnosis with less than a 6-month prognosis. 35% of people in the US who are referred to hospice spend 7 days or less in hospice. And this is really because people are referred late. The goal is to help keep the patient as pain-free as possible with the loved ones nearby. Most hospice programs offer home hospice services, which is helpful for patients who, like many of us, prefer to be at home rather than in a hospital. The majority of hospice patients are cared for in their own residence or with a loved one. So although home hospice programs are staffed by nurses, doctors, and other professionals, the main caregiver is the family member or friend who's responsible for the around-the-clock supervision of the patient. This person is with the patient most of the time and is trained to provide much of the hands-on care. A family member serves as the primary caregiver and may help to make the decisions for the individual who has the terminal illness. Members of the hospice staff make regular visits to assess the patient and provide additional care or other services. The hospice staff is on call 24 hours a day, 7 days a week. Hospice care is covered by Medicare, most Medicaid programs, the Department of Veterans Affairs, and most private insurance. Some limited cost sharing services might be available depending on your healthcare coverage, such as routine care, inpatient care, continuous care, respite care, medications, equipment and supplies, 24-hour on-call access to hospice staff, and grief support. Home hospice care usually costs less than care in hospitals, nursing homes, or other institutional settings, and this is because less high-cost technology is used, and family and friends often provide most of the care. Some other options are general inpatient care, which occurs in an inpatient facility. So if care cannot be managed where the patient resides, then the patient is moved to an inpatient facility until their condition is stabilized. This level of care does include coverage of room and board, and the beneficiary is not responsible for any co-insurance while they're at the general inpatient level of care. Then another option is inpatient respite care, which is provided in an inpatient facility because it's acknowledged that caring for a person with a terminal diagnosis can be difficult. This level of care is available to give a caregiver a rest. It's available for periods up to 5 consecutive days. And this level of care does include room and board costs also. Hospices, however, may charge beneficiaries 5% of Medicare's respite care per diem. So I also just wanted to give some hospice and palliative care resources that we have found helpful. I'm just going to leave this slide up for a minute in case you wanted to jot down any of these programs. All right. We also have some resources on the next slide as well that I want to make sure that we get to. And the CLRC also has a lot of resources that are available in different states to help navigate the process. These are some of our favorite national caregiving resources that we often use, but please feel free to contact us and we can try to search for local resources near you. If you're searching for resources for a patient or a survivor, often it's best to search by the person's diagnosis. So for example, search for programs that offer assistance to patients with leukemia or breast cancer specifically, if that is what the person's diagnosis is. And that is the end of our webinar here today. I hope that you found some of this information useful. I'm going to go back to that slide with all the resources on it. We just wanted to say thank you for taking time out of your day and for providing caregiving assistance to the people that you care about. And I'm going to leave it back on this slide, and then we'll take a few minutes and see if there are some questions. So one question we have is if we can have access to this presentation. We don't normally give out our direct presentations, but we do post them on our YouTube station and through our website. So you can feel free to come back to this presentation if you found it helpful. Hopefully you did. The next question is, how do you revoke a power of attorney, whether if you can do that by creating a new one. Because that varies so much state to state, I don't want to give any direct legal advice about that. But yes, it is possible to revoke those powers of attorney, and generally it's not too challenging to do that. We do have some good sort of state-specific questions as well, which you can feel free to fill out an intake form online. We have some other personal questions as well, which please feel free to fill out an intake at clrcintake.org. You can just pop on there, ask the question, and we'd be happy to give you a step-by-step process for being able to talk more about all of these topics. I really do appreciate all of the questions that we've received. Looks like that that is about it. So rather than just extending, I think we'll end it a little bit early. So hopefully you can enjoy your afternoon. If anything comes up, please, we're a free resource, so we really hope that you reach out to us. If anything comes up, please let us know. But again, thank you for all the work that you're doing as caregivers.